I see quite a few people registering, so I'm just going to give them a minute to log in, and then we'll kick off. All right, I think we should kick off. Good day, everyone. Welcome. My name is Mike Currie. I am a competition lawyer and director at Primerio International, based in Johannesburg. I would like to welcome my colleague, Mweshi Mutuna, who is Primerio's in-country partner in Zambia and a very accomplished competition lawyer herself. And then also a special and warm welcome to James Chalungumana, who is from the Competition and Consumer Protection Commission of Zambia. James is the Chief Investigator of the Cartels and Restrictive Practices division within the CCPC. I think from our perspective, we have certainly, in advising clients in competition law related matters across the continent, and having been involved in a number of advocacy initiatives, the Primerio team has certainly experienced an uptick in competition law enforcement beyond just sort of merger control issues. And I therefore think it makes today's discussion particularly timely, because in our experience, and we're certainly seeing the Zambian authorities among the leading agencies in terms of adopting a more robust enforcement regime tackling various cartel and restrictive practices within Zambia. So James, thanks very much for joining us. We only have 1 hour. I know there's lots that we want to do cover on today's session. I do want to try and leave some time available at the end for questions from the audience. I'm not sure how much time we're going to have available, so the audience, please feel free to send through any questions or comments you have as we progress with this discussion. But I then want to jump straight into it. So James, thank you very much for agreeing to speak with us. James, if you could give us a brief introduction in terms of an overview from the Commission's perspective and from your division's perspective in particular, in respect of the sort of more recent trends and priorities from the Commission in terms of not only priority sectors that you're looking into, but also the types of restrictive practices. What have you been involved in? Where are you dedicating the majority of your resources to? And can you give us a bit of insight into the key enforcement efforts from your perspective?
Thank you, Mike. Good afternoon to you. Good afternoon to Mweshi and to all of the attendees for this webinar. As agreed, this webinar is really timely, and thank you for having extended an invitation to talk to the CCPC. So as you've rightly said, I think the CCPC has had robust, not only enforcement techniques and initiatives. There's been a whole lot of proactive engagements. I think we'll get to that later. We have things like settlement, leniency, and other such initiatives that are aimed at not only providing punishment to erring persons and enterprises, but also aimed at providing preventive measures. So we have a dual mandate, Mike, which is to look at the entire economy. All of the activities, the economic activities ongoing in the economies, the CCPC has to look at. And the dual mandate, as you may be aware, is on competition and consumer protection. So in terms of where we are looking, ideally we're looking where there's more concentration of economic activity. but not to shun other sectors. The CCPC has looks at transactions worth $1 and worth millions of dollars almost the same way. So we have recently had trends, obviously because of the pandemic that's ongoing. We had a lot of issues, especially on consumer protection at the advent of the pandemic, where we had a lot of either excessive pricing of products that are preventive for the COVID-19 virus, products such as hand sanitizer, hand wash liquids, and things like that. We've also had instances of increased or excessively priced medicines. So some medicines will have a misconception as to being a preventive tool, or rather a curative tool for the COVID-19, and these will have demand rising through the roof. And because of this, we have misgivings by enterprises and even persons. So we'd have instances where one person would purchase a truckload of these products and go and double, triple the price in a place where there's high demand and the products are not available. So those are some of the things we sort of looked at the advent of the COVID-19. But more recently, you might be aware, we had the cement cartel. Of course, I may not go into much detail on that because of the matter being sub judice. We had 3 of the enterprises involved in that cartel appeal some of the decisions or all of the decisions of the Board of Commissioners of the Competition and Consumer Protection Commission in the Competition and Consumer Protection Tribunal. So we may not dwell on that, but that's a sector we had actively looked at. And interestingly, the decision came out early 2021, but we had been looking at the sector for the past years. We looked at the sector as far back as 10 years ago for some restrictive agreements. We looked at it for vertical agreements that were anti-competitive between these companies and their distributors and things like that. So the cement cartel was definitely one interesting investigation that we conducted. We've had others. We've had other sectors that are not highly spoken of. The matter is also sub judice, but we had the fingerlings cartel, where we found that there was collusion amongst 7 fingerlings producers and distributors, and 2 of them have appealed the decision of the Board of Commissioners of the CCPC, and others have since paid the fine and were still engaged in other enforcement mechanisms for those that may have not come forward with either an appeal or paying the actual fine. So another sector that we keep an eye on because it brings up issues a lot is in the same vein with the cement vertical agreements between manufacturers and their distributors. So this is cross-cutting in all sectors where we have a vibrant manufacturing sector and we have a vibrant distribution market in the downstream, whether it's manufacturing of alcohol, soft drinks, various beverages, it could be cigarettes, it's different sectors, but all of these pose their own challenges where restrictive business practices are concerned. So our resources are mostly in the fast-moving consumer goods, but that's also not to forget the manufacturing I've mentioned, the financial sector. But all in all, Mike, we look at all of the sectors, and we do have robust initiatives and techniques and other such mechanisms to ensure that we sort of have an eyes view over all of the sectors. So as you may be aware, we have a lot of sector regulators in almost all of the sectors. So we also have vibrant memorandums of understanding with each one of these. As you might be aware, they may be looking at competition as well and consumer protection mostly. And we also look at the same, but ours is broader, and they sort of bring in at times a specialized approach to a particular sector, and we don't shy away from sharing resources, sharing knowledge, and seeing how we could share initiatives, be it capacity building, or even enforcement mechanisms that we share with these institutions. So those are some of the things that we're doing, Michael. I know it probably brings to your head a number of issues spinning from that, but that's the purpose of this, so we could engage further.
Yeah, perfect. Thanks, James. That's all very interesting. And before, I know we can't get into specific details on the cement cartel, but there's certainly a number of elements of that which is all publicly available, which I do want to touch on. And before I get Mweshi's thoughts on this, I wanted to turn to your comment about looking at distribution agreements, particularly in the FMCG sector. The issues that you're looking at, is it predominantly based on concentration issues as well, or are you looking at broader fairness in terms of fair trade practices, shall I say, as opposed to pure traditional competition issues? What is the sort of, what are the key issues that are concerning from the Commission's perspective?
Thank you, Michael. So we look at both from our perspective, because firstly, most of the manufacturers that we have turn out to be dominant firms. So where there's a dominant firm and they have the market power, they tend to sort of give agreements that are half-baked or that are anti-competitive or that favor them, because obviously they have more bargaining power and they're the owners of these products. So we do look at concentration of power and how it's affecting the downstream players in the distribution market. So sometimes it's issues of, conditions that are unfair or that are untenable. You find that maybe the amount of capital required for you to deposit with this large manufacturer in the FMCG industries is through the roof. And you find that most of these distributors are either local distributors who maybe get a facility from the bank and they need to get their business up and running, but mostly because they have less bargaining power, and these large manufacturing firms in the FMCG sector tend to apply conditions that may not be favorable to these distributors. So as a proactive approach, we encourage themselves, the dominant firms, the powerful firms, the manufacturers, to come forward and give us these agreements. And then we go through them and look at them for any anti-competitive behavior, any resale price agreements, anything that would disadvantage the consumer and even the distributors. So that again comes to the second part of your question. Yes, we do look at fairness. So the fairness has to be looked at on several levels. Obviously, beginning with fairness on the distributor themselves. Are you having these goods distributed to their point of sale in a rural area, for instance? You're giving a distributor who's 20 kilometers from your manufacturing firm and one who's 600 kilometers from your manufacturing firm the same terms and conditions. So those are things we look out for, because we believe that there must be, for instance, an incentive for the one who's 600 kilometers away from you, because that also works for you as a manufacturer. You need these institutions to distribute for you to far-flung areas, because then you have some sort of countrywide footprint with your product or your service because of these distributors. So we encourage such. We look at obviously territorial restrictions and things like that. You find that a distributor has maybe the capacity to distribute the product in 2 provinces, but they're restricted to 1. So that becomes a concern for us. And as you know, most issues on competition law are on a rule of reason basis if they are not per se violations. So we tend to look at it from both angles, the concentration of power and the fairness. So the fairness also not only on the distributor goes down to the consumer as well. What kind of deal are the consumers getting? Is there resale price maintenance? Is the recommended retail price being followed? Is the consumer getting goods that are about to expire because of the distance and all of those things? So it's a multi-sector approach that we take, and it becomes more interesting because when these firms come forward, some of them know that some of these things are unfair, but they sort of try to justify them. So we tell them, this is unfair, can you justify it? And depending on the justifications they give, we then ask them to change their agreement, make amendments to it. And we also follow up, Mike. We just don't tell them, here's a paper that's revised. We need to make sure that in the 3 years the agreement is enforced, they're following things that are in that agreement. So we speak to the distributors, we speak to the consumers, and sort of just to get a feel and know that that agreement, which we deemed as fair, is being followed to the latter.
So if I've understood this latter part of yours, the Commission is quite open and willing to engage with parties on a proactive basis to assess their, let's say, distribution agreements and ensure that there are no red flags from the authorities' perspective, and then provided the firms implement those agreements as put forward, the Commission is generally comforted, as opposed to a view where the Commission says, well, this is the law, it's up to the firms to decide whether their conduct is compliant with the law or not. You prefer to have a more proactive engagement with firms in the industry.
Yes, Mike. Currently, we're looking at several agreements. We're looking at about 3 agreements from the fast-moving consumer goods sector. And all of these are proactive ways by the Commission. So you need to notify us of what agreement you have, and we see if it has any anti-competitive elements in it. And as such, we have another type of agreement where you know that this is anti-competitive, but you try to justify it. And when you justify it based on certain criteria, the Commission could give you the go-ahead to implement it. For instance, our Act provides for agreements that are sort of anti-competitive but are maintaining or promoting exports from Zambia, for instance, or they're promoting technical economic progress. So the Act allows for us to exempt such agreements in a proactive manner. We don't want to find this agreement in effect, then we find that it has anti-competitive effects, then we have to penalize you. But when you come forward in a proactive manner and say, this is what I'm trying to do, I want my distribution in such a province to be exclusive because I gave this distributor a warehouse and a truck, so they can't store a competitor's products in a warehouse that I bought them, and they can't ferry a competitor's products in a truck that I bought them. So those are the kind of justifications that come forward. And yes, Mike, the Commission is really proactive with such agreements between manufacturers and the distributors.
Perfect. No, very helpful. Thanks, James. Mweshi, I want to bring you in here. You obviously sit on the different other side of the fence, so to speak, representing many clients in competition law matters. What are, from your perspective, now that we've got James on the line here, what are some of the issues that perhaps from business or perhaps just from a private practitioner's perspective, you find challenging or concerning from providing an advice perspective, whether it's a procedural issue or not? Are there any things which strike you and issues which you would like to pose to James?
Thanks for that question, Mike. James, good afternoon. Afternoon to the audience.
Hi, Mweshi. Good afternoon.
Thanks. There are several issues which I would like to bring out from a practitioner perspective and based on interactions with firms that I have represented. But I think I will try to limit it to the 3 main issues that have arisen for the sake of time. And the key thing would be the amount of time that a firm or an enterprise that is under investigation is given to respond to a complaint against it. So you will find that from what James said in his opening statement, the Commission can take years investigating a party. But then when they do send you a preliminary report, you find that the client is given 7 days to respond to a voluminous, very detailed report, which is setting out the allegations against them. And the economic assessments as well, you probably find that the investigation is spanning the course of 3 to 5 years, immediately preceding the date when the report is prepared. So what we normally get is a client concerned that whilst the commission has had the luxury of time, they have 7 days in which they have to run around, gather facts about these allegations, which are 3 or 5 years old, and present it in a very cohesive and reasonable manner, which the commission will be able to understand and hopefully find them not wanting. So that timing imperative is a very key issue. There are times from experience where a client will be able to ask for an extension, and granted, the commission will give it to them. But there are times when you don't get that. So I think really the 7-day period, that policy is one that should be revisited. The other issue that commonly arises is the evidence that the commission relies on. So obviously when they're doing their investigations, there's the documents or other forms of evidence gathered based on dawn raids, questions sent to the firms under investigation. Then there's also information that's gathered from competitors and customers, consumers. Now, when you have your report, the commission sends their report. They're referring to that evidence, but it is not presented to the firm under investigation. So it tends to create the impression that there is no full disclosure and the firm under investigation does not have the benefit of interrogating the evidence upon which the commission is relying to find them, to accuse them of infringing the act. So it would be nice from my perspective as a practitioner sitting on the opposite end of James, if we could be given the opportunity to interrogate some of the evidence that the commission is basing its investigation on. I do understand that there will be issues of confidential information, but there's definitely supposed to be an opportunity to have a look at any exculpatory or incriminatory documents, especially since you, Mike, could interpret a document one way, perhaps out of context, but if I'm given an opportunity to look at it, I could tell you the context and a different interpretation or a different way of looking at it. So that's one of the major concerns that is there, because usually we tend to see the documents, the underlying evidence the commission has relied on at the appeal stage before the tribunal. And the last one I will touch on, looking at time, is press releases. So you will find that when an investigation starts, perhaps like, let's say the fingerlings cartel. I wasn't part of it. I don't know anything about it, but let's just give a hypothetical of the commission begins its investigation into their activities and releases a press statement saying they are looking into it. Most firms will find that to be rather damaging because that is the preliminary stage. You have not yet gathered the actual evidence which finds them to have breached the act. And therefore there is that fear of reputational damage that they engage in conduct which falls foul of the law, and also the potential for damages claims arising. So from my perspective as a practitioner, I think those are the three key things.
James, I'm going to throw this back to you to maybe respond to some of Mweshi's concerns, and perhaps you can do that in a way of just briefly talking us through how a investigation typically plays out internally. So if we took a investigation to an abuse of dominance case, perhaps you could just briefly for the audience outline the process, and in doing so, perhaps pause at the relevant junctures where you think there's a response, if you'd like to respond to some of the concerns that Mweshi has raised.
Okay, thank you, Mike, and thank you, Mweshi, for those interesting observations. So those three issues you bring out, Mweshi, are very interesting, and I must mention that these issues are handled within a set guideline. So I'll begin by saying the amount of time, for instance, which we give firms to respond. So firstly, this is given by the guidelines. We have a set of guidelines, administrative guidelines that we use. And usually we have situations where council asks for an extension in which to respond. It's very rare. It's seldom that the commission will deny granting this extension because obviously of the reasons that are put forward. Sometimes we have cases that are straightforward and an extension is asked for, it's granted, but then after the extension period ends, we still don't get the response. So some of those are the situations that we're faced with. But usually, when council asks for an extension from the commission, it's usually granted. The 14 days in which to respond to a notice of investigation, Mike, it's for you to give your side of the story. It's not obviously right, even using the laws of natural justice, that someone should say something about you and you don't have the chance to respond. So the 14 days, I think, is sufficient time for you to gather your thoughts on what allegations are being brought forward. As for the 7 days when the report is issued to the parties, usually this has a provision for an extension to be granted once it's asked for. When investigations are complete, Mike, the decision of the commissioners of the commission has a 30-day window in which an appeal could be lodged in the Competition and Consumer Protection Tribunal. So where it's felt that the time is insufficient, we have granted extensions, some even up to the tune of 30 days. We have some lawyers, obviously I won't mention name, they'll ask for 60 days, Mike, and that sounds a bit unreasonable, so we'll give maybe 30 days, and that's sufficient time for them to present their findings. So for the evidence that's relied on, Mweshi, cartel investigations are highly secretive, and the only assurance I can give you is that all of the evidence we gather is done so in a legal manner. But then again, because of some of the sources that we get the information from and confidentiality concerns, not everything can be given. But key pieces of evidence relied on in investigations, especially cartel investigations, are usually presented at a certain point, especially when the parties are told what the findings of the commission are. In terms of press releases, we usually don't issue press releases when investigations are commencing. I know, Mike, you asked me to speak about abuse of dominance, but I'll just speak about the, sensitivity of cartel investigations. Once we start investigating a firm, whether it's by the commission's own initiative or it's by a complaint lodged by a person or another enterprise, for cartel investigations, we mostly don't inform the parties that are being investigated. So Section 55(4) of our Act allows us to conduct these investigations. They could go on for even 6 months until such a time we feel that we could conduct a dawn raid. Then we do that and gather the evidence that we need. We usually don't issue press releases before these investigations are concluded. This is obviously because of reasons that are even more detrimental to the commission's investigations, because once we issue press releases, then we're putting out the information in public, and evidence that would be gotten at a later stage would be jeopardized and would otherwise not get that evidence. So in terms of procedure, Mike, the commission relies on Section 55 of the Act. That's where we get our powers from to investigate any issue, whether it's on consumer protection, it's on competition, whether it's a party that we tell immediately that we're investigating, or we present with a notice of investigation at the point of conducting a dawn raid. It's this section of the Act where we get this power to do that from. So that said, Mike, cartel investigations are highly secretive. You know, cartel organizations or cartel participants know that there's an aspect of criminality in it. Apart from criminality, there's an aspect of high civil penalties, up to 10% of your annual turnover. And at times, it's on concurrent years. If we are certain that the cartel went on for 5 years, we could charge up to 10% for of the turnover of each particular year. And this becomes a very high figure. And these participants know that, and they know what they're doing, and they try as much as they can to ensure that these agreements or these proceedings are in secret, like utmost secrecy. And you wouldn't believe the length of methods or round robin that you have to conduct just to gather evidence or to prove a particular cartel being in existence.
James, I want to pick up on this point about cartel enforcement and the tools and efficacy in which you've used some of these tools. You've mentioned some dawn raids. I want to get to that. But before we move off the topic, well, I suppose it's a related topic to what Mweshi raised about the level and extent of economic evidence that is considered and put forward and assessed internally by the Commission in coming to a conclusion. You mentioned that, for example, 30 or 60 days you think is more than enough time for parties to put together comprehensive responses. Certainly an experience that I think even from a commission or agency perspective, to put together, for example, a comprehensive economic assessment where you first need to assess levels of dominance, which, if you wouldn't mind just giving us also a little bit of insight into how the Commission approaches dominance. Is it on a market threshold basis or a pure market power basis? If you could give some insight into that, that would also be helpful. But all of that presumably requires quite a lot of economic analysis. And then, of course, a lot of empirical data needs to be assessed, well, collated, assessed, and then interpreted. To what extent does the Commission grapple with all of that? And what is the reliance that the Commission places on all that evidence? In other words, does the Commission bring in expert economists? Do you have experts in-house who really assess and deliberate on all of that, that economic evidence? And economic evidence always plays a role, but there's always, I suppose, a question of a degree. And I'd like your thoughts on that as well.
All right, thank you, Mike. Obviously, when we're looking at investigations, we don't only look at a piece of evidence. We tend to tie that to an actual event on the market. So, for instance, when we find that there was an increase in the price of a particular product and we suspect that there's cartel conduct in that particular sector, then when we gather the evidence, it must sort of be tied to actual market trends. For instance, if party A, B, and C all increase their price on a particular day, and we have gathered evidence of a particular nature in which this cartel, for lack of a better term, had implemented that agreement and were able to link it to market trends, then that becomes something that the Commission looks at and takes with keen interest. So in terms of in-house expertise, yes, Mike, we have in-house expertise, and we have a multi-sectoral supportive departments. For instance, we have our Directorate of Legal and Corporate Affairs who look at each and every case Mike, regardless of the department it's coming from, that's determined by the commission. It has to go through our legal department, because ideally the departments, the functional departments of the commission usually have business related professionals, but we do have able support from our legal department who sort of solidify what we've come up with. And in terms of evidence handling and all of those things, they ensure that we're handling evidence in the right manner. Our analysis is making sense, and mostly our interpretation of the act is as it's supposed to be, because everything that we do, Mike, is sort of governed and directed by the Competition and Consumer Protection Act. So sometimes the interpretation of certain aspects of the act becomes largely dependent on the guidance given by the legal department. But the commission has developed a lot of expertise over the years. The commission has been in existence since 1997, when it was the Zambia Competition Commission. And since that time, we still have professionals, Mike, who've been part of the institution since inception. And we have a robust capacity building program. We have a robust management trainee program. We have ways in which knowledge is passed on, precedence is created, and all of that. So yes, we do have the required expertise, Mike, to handle all of these matters that we are faced with. In terms of the second part of your question, dominance is provided for also by the Competition and Consumer Protection Act. So it's provided in two ways. A firm is dominant if they supply 30% or more of goods, that is individually in a particular market. It has to be in a particular relevant market, Mike. And the second instance is where 60% of or more of particular goods are supplied by not more than 3 enterprises. So now, looking at that 30% or the 60%, we could ascertain it based on their sales revenue to arrive at their market share. But then dominance, I must be quick to mention, is not an offense. Being a dominant firm is allowed in Zambia, but you must not use your dominance to engage in anti-competitive conduct. So some of the things that firms that are dominant and have market power do is they, engage in excessive pricing or predatory pricing. So where there's a new competitor in the market, they then price their products at lower than the cost of that product. And when this other competitor is out of the market, they then triple the price. So those are some of the misgivings that come with firms being dominant, or even imposing different conditions to transactions that are similar in nature. Or it could be denying someone, denying a person access to an essential facility. All of those are some of the abuses that come with a dominant firm that has market power. So there are some firms that are dominant but don't have market power. But for those that are dominant and have market power and engage in abuse of dominance, then we become very interested in their conduct.
Okay, interesting. So there's a sort of concept of collective dominance as well as individual dominance catered for in the legislation.
Yes, absolutely, Mike.
Okay, James, then rounding off on the topic of procedure. So is the takeaway then this, the Commission has set out guidelines that have certain dates by which parties are to respond, but provided respondents are able to demonstrate on reasonable grounds why they might need an extension, and presumably those reasonable grounds include the complexity of the matter at hand, the level of information that's it needs to assess or ascertain, the Commission is relatively open to granting extensions in order to allow respondent parties an opportunity to prepare a comprehensive response, not a rushed response just to get something in to have it say, but actually a well-considered response and able to engage economists, lawyers, its clients. And is that a fair summation of what you're articulating in response to some of the points that Mweshi had raised earlier?
Yes, Mike, absolutely. That's a fair summation of what I said, because the commission is not there to punish businesses or persons or erring enterprises. I like to give this example. The commission is like a referee, Mike, in a soccer match. If there's no injury or foul or whatever it is, then the referee just sort of runs around and sees what's happening. So the commission is not there to punish erring enterprises, and as such, we don't want to get milk from a stone, So if you come forward and say, look, this information is a bit much for us to handle, or asking for an extension, then definitely the extension is granted by our management.
Perfect. James, I want to move then quite quickly, so we've got 15 minutes left, quite quickly to discuss or to pick up on the cartel work, and in particular the different enforcement tools that the Commission particularly relies on and has found to be the most effective in its investigations to date. You've obviously mentioned dawn raids, you've mentioned leniency programs. We know that, I understand at least from the Competition Act, that offences are met with both a civil and a criminal penalty. Can you talk us through what, from your perspective, you found to be the most effective tools, and where you think that the Commission has experienced some challenges in pursuing the various tools available to you?
So, Mike, we have several ways in which we sort of gather evidence and investigate cartels, and I won't go into detail of all of them for obvious reasons. But look, we have great collaboration with other institutions. So we have other institutions that are placed at a vantage point better than us to give us particular information on particular conduct, which they can't investigate, but they have the information on that. So we sort of partner with them. We also monitor market trends. We survey the market. We conduct market surveys. This could go on for months or even years at times. We look at trends in the market and sort of ascertain particular market behavior. Some of the tools that are really most effective, in my opinion, is the leniency program. So we have an active leniency program. Although we haven't had many firms coming forward, but the leniency provides a very effective tool, because apart from providing us with the much information we need, it also provides the applicant with an opportunity to get immunity from fines and the imprisonment I mentioned, obviously depending on the degree of information they provide us, and also on whether they're the first one to approach the Commission, or they're the second or third marker, so on and so forth. The leniency provides for both vertical agreements and horizontal agreements. So it basically provides for cartels and all of those agreements that we spoke about in the preamble of this discussion. So if a distributor is not happy with what the manufacturer is doing, they could come forward and tell us about an agreement which they have with the manufacturer, which is anti-competitive. It could be, a sort of conniving manufacturer and distributor to disadvantage consumers, for instance. And this distributor doesn't want to be part of this agreement, so they could come forward and alert us on a particular vertical agreement that is anti-competitive. And the same goes with horizontal agreements, which are basically cartels. So we could have enterprises coming forward and giving us information which we previously didn't have about that particular agreement. So this is something that I think we're excited about as a Commission, because it's sort of a proactive approach by the Commission. And apart from being proactive, it sort of eases the burden of getting this information out on your own. We also have settlement, Mike. So at any point of the investigations, the party who's being investigated could come forward and say, hey, look, I'm not saying I'm guilty, but can we please end this? What can we do to have this go away? That's another initiative that the Commission is using in these cartel and restrictive business practice cases. So some of the other things that we're doing is just basic sensitization. So, we're creating a culture of responsible citizens in competition and consumer protection by going as far as creating clubs in school clubs, clubs in schools, I beg your pardon. So we have these small clubs in secondary schools, and they're taught about competition, about consumer protection at a tender age. And they're sort of growing up knowing not to engage in cartels, knowing to ask for a receipt when they buy a product, knowing to check for expiry dates and all of those things. So some of those things are all the way down to the ground, and they're really practical and they're effective, because when these are measured, you find that there's a correlation between where a lot of sensitization, advocacy, and groundwork is being done, and also instances of cases. So like I mentioned earlier, Mike, the Commission's intention is not to be a bulldog that bites at every slight anti-competitive or unfair trade practice happening. We would rather have everyone know that this is wrong and they don't do it. And that way we'll have a more proactive and preventive approach rather than a curative one. So those are some of the things that are really exciting about the Commission's work. And also we've had a general feel of the public sort of buying into what we do. Sometimes we just get calls, people calling in and asking, would like to know what investigations you're conducting at the moment, how they're affecting members of the public. Or we found these products that are expired. Can you please send inspectors to come and look at them? Or I suspect there's a cartel in this thing. How come the price of product A is the same in 10, 12 places I've visited the past 1 month or so? So we have the public also forthcoming, and that really shows that some of these initiatives that we've employed are really bearing fruit.
Hang off. Great. Mweshi, I saw you had your hand up.
Yes, I did, Mike. Clearly, an hour is not enough for us to have this, the kind of scale of conversation that we wanted to have with James. I was just thinking perhaps we might want to highlight the questions raised. I'm seeing that there are 5 questions from the audience, just to ensure that before we conclude the meet, they have had their questions attended to.
Yeah, absolutely. So I think there's, looking through a couple of them, I think one of the questions was, and it ties into a follow-up question, and very briefly, James, could you give us a quick rundown of how the Commission deals with excessive pricing cases or complaints during the COVID period, given that you wear both a Consumer Protection hat and a Competition Act hat? Is there interaction between the two departments internally, or is one department looking at it more closely than another department? What is the sort of approach from the Commission's perspective?
So, Mike, we have 2 departments that deal with competition, the Department of Mergers and Monopolies, and we have the Department of Cartels and Restrictive Business Practices. Then we have the Consumer Protection Department. So there's a very thin line between these departments. We sit together in most meetings. We're housed at the same building. We share information. We sit in some of we look at some of the issues that are cutting across both mandates. For instance, if you talk about the excessive pricing during COVID times, we conducted some of those exercises together with the Consumer Protection Department. So what we do is we have local authority inspectors. So these are municipal city council inspectors who are appointed by the Board of Commissioners. So they come forward. We get people from the competition departments and people from the Consumer Protection Department. And so when we're looking at excessive pricing in COVID times, so we look at the excessive pricing as competition departments, and the Consumer Protection Department will also look at whether these items are expired, whether they are safe, are they labeled properly, is the price that is displayed the price that is being charged, all of those things. So we did have a number of cases that we handled during the COVID times, and most of them were handled successfully, and I can safely confirm that right now the prices of most products are back to their normal or reasonable price, so to say. As you may be aware, Mike, we don't control prices, but where we find that a price seems to be excessive, obviously because of a dominant firm that has market power, then we tend to look at those instances. But sometimes, like I said, a trader seeing a multi-sectoral inspectorate enter their premises sometimes is deterrent enough for them not to engage in these things. And at times we effect the law to the latter and sort of have some of these traders punished as a deterrent measure. So we did successfully handle issues of excessive pricing during COVID times, and we still maintain an eye out on the market because we have all of these first, second, third wave, and they keep concurrently coming. And there's always a trader out there who wants to make a killing from people suffering. And as such, I could say right now we have a case which we opened on excessive pricing, which we're currently looking at. And obviously I can't mention more because would then jeopardize investigations. But these cases are concurrently being looked at by a multi-sectoral team. And sometimes it involves even institutions from the ones we have memorandums of understanding with that may not be from within the CCPC, but they're amongst our partners. And we as such get the desired results from these multi-sectoral engagement.
Perfect. James, I'm going to ask you three quick questions that have come from the audience that I hope you can address quite quickly for us. One is, when is any new legislation likely to come into effect? The other is a request for the Commission to publish its decisions, which I think does go a long way to assisting both firms and practitioners understand and appreciate a lot of what you've articulated on this call. And the third question goes to the heart of whether or not a decision by the Commission becomes immediately enforceable and remains in force subject to an appeal, or is that decision stayed pending the outcome of the appeal? If you could give a quick response to those three questions, that would be great. James, you're on mute if you are.
Oh, sorry, Mike. I was here talking to myself. So the decision by the Board of Commissioners becomes effective immediately. It's served upon the respondent or the appointed representative, such as their lawyers. That decision can be appealed against within 30 days of its receipt. So the Competition and Consumer Protection Tribunal is the sitting body which these appeals are made to. So the tribunal made a ruling and determined that they don't have the power, whether implied, they don't have the power to stay a decision of the Board of Commissioners. So that's in public domain. It was a judgment given in a 2019 appeal by a firm in the telecom sector. So they appealed against a decision of the Commission, and the tribunal, they asked for a stay of execution, and the tribunal rightfully explained to them that they didn't have the power to stay a decision of the Board of Commissioners. So to answer that, Mike, a decision becomes in force immediately. A decision by the commission, the commissioners, is given to the respondent. For the commission to publish its decisions, periodically this is done on our website. Perhaps we could look further for more recent decisions to be published, like in full, but nothing precedes anyone from calling the commission and asking for a decision that's in public domain. We have no reservations with giving out these decisions that are in public domain, and we have no problem, because at the point we give out a decision to the parties, it's usually void of any confidential information or any information that's containing economically sensitive information of one party, for example. In terms of reviewing the legislation, so the acts that we're using came into force in 2010 when the Competition and Consumer Protection Act number 24 of 2010 was passed. There are currently a few amendments that are ongoing to it, and I can't confirm when they will be complete, but there are some amendments to the act that are ongoing, obviously to sort of have the act become more efficient and effective. It's not to offer more punishment, Mike, it's just to become more efficient and effective. Yeah.
Great, thank you, James. I know we're wrapping up on an hour, and I apologize to Mweshi because I think I've stirred in a lot of time, and I know she's got a lot of issues on her mind that she has wanted to raise. And I think we might very well have a follow-up discussion on this. Mweshi, I don't know if you have remarks or general remarks on or issues you would like to that would make a good follow-up discussion, and then James, I'll give you an opportunity to make some closing remarks, and then I think we'll wrap this up. Thank you on my part. Thank you very much for the audience for the questions. I think it's been tremendously helpful, and again, thank you, James and Mweshi, for your participation.
All right, thanks, Mike. In closing, I would just like to thank James for his time and trying to give us his responses to the best of his ability. I do realize that he doesn't want to commit himself or be quoted should a case come up in the event that someone says, no, James in this webinar said ABCD. So we do respect your trying to draw boundaries when answering our questions, but I believe that he has adequately addressed them. But I would like to follow up with you, James, discussing the leniency program as a tool and an investigative tool. Perhaps we could have another webinar with you on that.
Thank you very much, Mweshi. I was just trying to respond to two of the issues on the chat as you were speaking. So thank you very much also for your time. I hope that this could be a series of discussions. Perhaps we could structure something like that. The Commission is open to proactive, cost-effective engagements such as this one. And we're definitely available every time that we're called upon, provided our schedules are free. Let's sort of come up with a way in which we could maybe have a series, maybe monthly or bi-weekly or something, and we could then pick it up, because we have different departments, different perspectives, and you could speak to a whole lot of issues. Hot issues right now. We could talk about pricing in COVID. We could talk about digital markets. We could talk about leniency, as you've rightfully proposed, Mweshi. So the Commission is definitely open for engagement in such a manner, and we value your partnership with us. We also value the contributions, questions that were presented by the attendees. Thank you very much, and we hope to engage soon in the near future.
Thank you, James. They sound like excellent proposals, and I'm sure our audience would be quite grateful if we took you up on that invitation. So we'll certainly do that. Thank you very much, and thank you, everyone. Hope to see you all soon again.